Question 1. A retired engineer gives securities advice to friends a few times a year and never charges for it. Under the Uniform Securities Act, he is it an investment advisor who must register? B. Not an investment advisor, because he is neither in the business of advising nor compensated for it. C. An investment advisor representative. D. A broker-dealer? The correct answer is B. He fails 2 prongs of the 3-part test. Occasional advice to friends is not being in the business of advising, and he receives no compensation. Either failure alone keeps him outside the investment advisor definition, so registration is not required. Question 2. Unless renewed, the registration of a broker-dealer, agent, investment advisor, or investment advisor representative expires. Is it A. Every 2 years on June 30th? B. On December 31st of each year? C. Only when the registrant ceases doing business in the state? D. On the anniversary of the original effective date? The correct answer is B. State registrations run on a calendar year cycle and expire on December 31st unless renewed by filing the required renewal and paying the annual fee. There is no rolling anniversary date and no 2-year cycle under the Act. A registrant who stops doing business must affirmatively withdraw rather than simply let the file lapse. Question 3. A state-registered investment advisor must keep its Form ADV current by, is it A. Refiling a brand new Form ADV every year? B. Amending it only when the administrator specifically asks? C. Filing an annual updating amendment within 90 days of its fiscal year end and promptly amending any materially inaccurate information? D. Never amending it once the registration is granted? The correct answer is C. Advisors must file an annual updating amendment to Form ADV within 90 days of the end of their fiscal year and must promptly amend the form whenever information becomes materially inaccurate. They do not refile a new form from scratch, wait to be asked, or leave the form frozen after registration. Question 4. Which of the following would not meet the Uniform Securities Act's definition of a person? Is it A. A city that issues revenue bonds? B. A limited partnership formed to invest in real estate? C. An unincorporated investment club? D. An individual who died last month? The correct answer is D. A person is defined broadly to include individuals, corporations, partnerships, associations, joint stock companies, trusts, unincorporated organizations, and governments or political subdivisions. The classic exclusions are a deceased individual, a minor, and an individual who has been judged mentally incompetent. Partnerships, municipalities, and unincorporated associations all fall squarely inside the definition. Question 5. To make a late trade appear timely, an agent changes the date on the order ticket to the previous business day. This is it A. Acceptable because the trade itself was valid, provided the firm files the required consent to service of process and the administrator does not enter an order to the contrary? B. A clerical correction? C. Permissible with the customer's consent? D. Falsification of records, a prohibited and unethical practice? The correct answer is D. Backdating or otherwise altering firm records falsifies the books and records regulators rely on and is a prohibited practice regardless of whether the underlying trade was otherwise valid. It is not a clerical fix, and no customer consent can authorize a falsified record. Question 6. Which of the following would be considered a sale under the Uniform Securities Act? Is it A. A pledge of securities as loan collateral that is never foreclosed? B. A gift of assessable stock? C. A stock dividend for which shareholders give up nothing of value? D. A bona fide gift of fully paid, non-assessable stock to a family member? The correct answer is B. The Act treats a gift of assessable stock as a sale because the recipient takes on a potential future obligation, which functions as consideration. A bona fide gift of non-assessable stock involves no value given and is not a sale, and a stock dividend for which nothing is surrendered is likewise excluded. A pledge creates a security interest rather than a transfer of ownership for value. Question 7. Which of the following may the administrator not do? Is it A. Issue an injunction or sentence a violator to prison? B. Subpoena records located in another state? C. Deny an application for registration after notice and an opportunity for hearing? D. Issue a cease and desist order? The correct answer is A. Injunctions in criminal sentences are judicial remedies. The administrator must ask a court for an injunction and must refer evidence to a prosecutor for criminal charges. Administrative powers include denying, suspending, and revoking registrations after notice and an opportunity for hearing, issuing cease and desist orders, and compelling the production of records wherever they are kept. Keeping the administrative and judicial roles straight is a heavily tested distinction. Question 8. A state-registered investment advisor collects advisory fees well in advance. Under NASAA rules, if it collects substantial prepaid fees 6 or more months ahead, it generally must, is it A. Do nothing special? B. Register with the SEC instead of the state? C. Include a current balance sheet in its brochure, because collecting more than $500 per client, 6 or more months in advance, is treated like custody? D. Post a $1 million surety bond? The correct answer is C. Collecting prepaid fees of more than $500 per client 6 or more months in advance is treated as a form of custody and triggers the requirement to disclose the advisor's financial condition through a balance sheet in the brochure. It is not an SEC registration trigger, and the $1 million bond figure is invented. Question 9. A registered broker-dealer discovers that information in its original state application has become materially inaccurate. The firm should, is it A. Correct the information only if a customer or the administrator asks about it? B. Promptly file an amendment with the administrator correcting the information? C. Withdraw its registration and file a new application? D. Wait and correct the information at the next annual renewal? The correct answer is B. Registrants must keep their filings current and promptly amend any information that becomes inaccurate or incomplete in a material respect. Waiting for renewal or for someone to ask leaves a false filing on record, which is itself a ground for discipline. Withdrawing and refiling is a drastic step the Act does not require for a simple amendment. Question 10. The term fraud is used in the anti-fraud provisions of the Uniform Securities Act. Is it A. Is limited to common law deceit and requires proof of intent to defraud, since the administrator generally treats this as a routine matter resolved through the state's ordinary coordination procedures? B. Applies only to registered securities? C. Is broader than common law fraud and is not confined to the elements of common law deceit? D. Requires proof that the victim actually lost money? The correct answer is C. The Act's concept of fraud, deceit, or manipulation is deliberately broader than common law fraud and is not limited to its traditional elements. The anti-fraud provisions reach any security, exempt or not, and apply to offers as well as sales, so proof of a completed loss is not always required. Question 11. Regarding the books and records of registered broker-dealers, the administrator may, is it A. Prohibit any record-keeping at all? B. Require records but never set a retention period? C. Impose requirements that exceed the federal standards for firms also registered with the SEC? D. Require registrants to make and preserve specified records for prescribed periods, not exceeding the federal requirements for firms also registered with the SEC? The correct answer is D. The administrator prescribes record-keeping and retention requirements, but for firms also registered with the SEC, state requirements may not exceed the corresponding federal ones, a coordination Congress imposed through NSMIA. Records are mandatory and time-limited, so prohibiting records or refusing to set a retention period misstates the law. Question 12. A registrant disagrees with a final order entered by the administrator. The registrant may, is it A. Demand a jury trial before the administrator? B. Obtain judicial review by filing a petition in the appropriate court within 60 days of the order, though filing generally does not stay the order. C. Appeal directly to the SEC. D. Ignore the order until the administrator brings an enforcement action. The correct answer is B. Final orders are subject to judicial review on a written petition filed within 60 days, and the reviewing court examines the administrative record. Filing the petition does not by itself suspend the order unless the court so directs, so the registrant must comply in the meantime. State administrative orders are not appealed to the SEC, and administrative hearings are conducted without juries. Question 13. Under the NASAA brochure rule, a state-registered investment advisor must deliver its written disclosure brochure, or Form ADV Part 2, to a prospective client. Is it A, within 30 days after the contract is signed? B, no later than entering into the advisory contract? If delivered less than 48 hours beforehand, the client generally gets a 5-business-day penalty-free withdrawal right. C, only upon the client's written request. D, once every 3 years? The correct answer is B. The brochure rule requires delivery at or before entering into the advisory contract. If the brochure is not delivered at least 48 hours in advance, the client must be given the right to cancel within 5 business days without penalty. The advisor must also deliver or offer the brochure annually, not merely every 3 years or on request. Question 14. Regarding written customer complaints, a broker-dealer is generally required to: is it A, discard complaints once they are resolved? B, keep complaints only if litigation is filed? C, record, retain, and make available for inspection written customer complaints and the firm's responses? D, forward every complaint to the SEC within 24 hours, provided the firm files the required consent to service of process and the administrator does not enter an order to the contrary? The correct answer is C. Firms must record and retain written customer complaints, and the dispositions of those complaints, for the prescribed retention period and produce them on examination. Complaints are not discarded when resolved, retention does not depend on litigation, and ordinary complaints are not automatically filed with the SEC on a 24-hour clock. Question 15. Which statement about the administrator's rulemaking authority is correct? Is it A, rules take effect only after approval by the SEC? B, the administrator may adopt rules but never prescribe forms? C, rules may be adopted in secret and enforced immediately? D, the administrator may make, amend, and rescind rules, forms, and orders necessary to carry out the act, and rules must be published before they can be enforced? The correct answer is D. The Act gives the administrator broad authority to adopt, amend, and rescind rules and forms and to issue orders as necessary to administer the statute, subject to publication so that regulated persons have notice. No rule may be enforced against a person who had no notice of it. State rules are not submitted to the SEC for approval, though they cannot conflict with preemptive federal law. Question 16. Which statement about a state securities registration statement is correct? Is it A, it may be filed only by the issuer itself? B, it may be filed by the issuer, by any other person on whose behalf the offering is made, or by a registered broker-dealer, and it is generally effective for 1 year? C, once declared effective it remains effective indefinitely? D, it may not be amended after the effective date under any circumstances? The correct answer is B. The Act allows the issuer, a selling shareholder or other person on whose behalf the offering is being made, or a registered broker-dealer to file the registration statement. Effectiveness generally runs for 1 year from the effective date, so a continuing offering must be renewed. Post-effective amendments are permitted, most commonly to increase the number of shares registered. Question 17. An agent recommends that clients buy a small company's stock without telling them that he personally owns a large block he hopes to unload at a higher price. The failure to disclose his position is it A, a prohibited failure to disclose a material conflict of interest? B. Acceptable, because his personal holdings are private. C. Acceptable if the stock is otherwise suitable. D. A violation only if he sells while the recommendation is outstanding? The correct answer is A. An agent's personal position and intent to sell into his own recommendation is a material conflict of interest, a form of scalping, that must be disclosed. Concealing it is fraudulent and unethical. His holdings are not simply private once he recommends the stock. Suitability does not cure an undisclosed conflict, and the violation lies in the non-disclosure itself. Question 18. An individual will both sell securities for a broker-dealer and provide advisory services for the firm's affiliated state-registered investment advisor. This individual must, register only once, in whichever capacity occupies more of his time. B. Register only as an agent, because that is the higher standard. C. Register separately as an agent of the broker-dealer and as an investment advisor representative of the advisor. D. Not register at all, because the two firms are affiliated? The correct answer is C. Agent and investment advisor representative are distinct registration categories tied to distinct functions and distinct firms. Performing both roles requires registration in each capacity. Affiliation between the broker-dealer and the advisor does not merge the two registrations, and neither one is a mere subset of the other. Question 19. A corporation issues short-term notes to raise working capital. For the notes to fall within the commercial paper exemption, they must generally, mature within 9 months, be rated in one of the top categories by a nationally recognized rating agency, and be issued in large denominations. B. Be guaranteed by a commercial bank. C. Be sold only to individual investors. D. Be convertible into common stock. The correct answer is A. The commercial paper exemption is limited to high-quality, short-term paper, a maturity of 9 months or less, a top-tier rating, and denominations large enough that the instruments are bought by institutions rather than small retail investors. Convertibility would give the note an equity feature and take it outside the exemption. Neither a bank guarantee nor a retail-only distribution is part of the test. Question 20. A firm offers a wrap program charging one asset-based fee that covers advice and all transaction costs. With respect to this program, the firm must, charge separate commissions on each trade in addition to the wrap fee. B. Disclose the wrap fee arrangement, because bundling advice and execution into one fee generally brings the program within the advisory rules. C. Do nothing, because a single fee needs no explanation. D. Obtain the administrator's approval of the fee amount? The correct answer is B. Wrap fee programs bundle advice and execution into a single asset-based fee and generally implicate investment advisor disclosure obligations, including a specialized wrap fee brochure. Charging separate commissions on top would be double charging. A single fee still requires disclosure, and the administrator does not set the fee amount. Question 21. A broker-dealer's state registration is suspended for 60 days. During the suspension, the registrations of the agents employed by that firm, are also not in effect, because an agent's registration is effective only while the agent is associated with a registered broker-dealer or issuer. B. Transfer automatically to any affiliated firm. C. Remain fully effective because they were registered individually. D. Are automatically revoked and must be reapplied for? The correct answer is A. An agent's registration is derivative. It is effective only while the agent is associated with a registered broker-dealer or issuer, so suspending the firm suspends the agent's ability to act. The registrations are not revoked outright, so a brand new application is not automatically required. Registrations do not migrate to affiliates by operation of law. Question 22. A customer sells securities and is owed the proceeds. The agent delays sending the funds and briefly uses them for the firm's short-term needs. This is it acceptable if the customer is eventually paid in full? B. Acceptable because the firm has custody of the account, since the administrator generally treats this as a routine matter resolved through the state's ordinary coordination procedures. C. A minor timing issue of no regulatory concern. D. A prohibited failure to promptly pay funds owed and an improper use of customer money. The correct answer is D. Failing to pay or deliver promptly the funds or securities owed to a customer, and using customer money for the firm's own purposes, are prohibited practices. Eventual payment does not cure the misuse, and holding an account does not authorize borrowing customer funds without permission. Question 23. An investment advisor organized as a partnership must, under NASAA rules, ensure its advisory contracts provide that ISDA fees will never increase for the life of the contract, a conclusion the NASAA model rules are commonly understood to support for a person already registered and in good standing elsewhere. B. The advisor guarantees a minimum rate of return. C. The advisor will notify clients of any change in the membership of the partnership within a reasonable time. D. Clients waive their right to sue the advisor. The correct answer is C. A partnership advisor's contracts must require that clients be notified of any change in the membership of the partnership within a reasonable time after the change. A fee freeze and a guaranteed return are not required, and a clause purporting to waive a client's rights under the Act would itself be void. Question 24. The publisher of a general circulation financial newspaper that offers regular market commentary and non-personalized stock suggestions is it A, an investment advisor that must register, on the view that the relevant exemption stays available to the party unless and until the administrator revokes it by a formal order? B, excluded from the definition of investment advisor, because bona fide publications of general and regular circulation are accepted. C, an investment advisor representative. D, a broker-dealer? The correct answer is B. A bona fide newspaper, news magazine, or business publication of general and regular circulation is excluded from the investment advisor definition so long as its content is not personalized to a particular client's situation. The exclusion can be lost if the publication begins giving individualized, tailored advice. Question 25. Which statement about registration by qualification is correct? Is it A, it is available to any issuer, requires the most detailed disclosure, and becomes effective when the administrator so orders? B, it may be used only when a federal registration statement has also been filed. C, it becomes effective automatically 2 business days after filing. D, it is available only to issuers listed on a national exchange? The correct answer is A, qualification is the most demanding method, requiring extensive information about the issuer, its officers, its capitalization, and the use of proceeds, and effectiveness comes only when the administrator orders it. It is the universal method, available to any issuer, and is typical for purely intrastate offerings with no federal filing. Automatic effectiveness on a short clock describes notification, not qualification. Question 26. 2 agents registered with the same broker-dealer agree to split the commission on a joint account they service together. This arrangement is it A, prohibited in all cases? B, generally permissible, because both are registered agents of the same broker-dealer? C, permissible only with the administrator's prior approval? D, permissible only if the customer pays a higher commission, assuming the applicant has satisfied the net worth, surety bonding, and qualification examination conditions the administrator may impose? The correct answer is B, commission sharing among agents registered with the same broker-dealer, or affiliated firms under common control, is permitted. The prohibited abuse is sharing with an unregistered person. No administrator approval is needed, and the customer is not charged more because the split is internal to the compensation. Question 27. An agent sells a customer shares of a new registered offering but never delivers the required prospectus. This omission is it A violation, because required prospectus delivery is part of a lawful offer and sale? B, acceptable, because the customer can find the prospectus online, an interpretation that several states incorporated when they enacted the later revisions to the Uniform Act and its accompanying rules. C. Acceptable if the customer is sophisticated. D. Curable only by rescinding the trade. The correct answer is A. Failing to deliver a prospectus where one is required is a prohibited practice and a violation of the disclosure obligations attached to the offer and sale. The document's availability online and the customer's sophistication do not excuse non-delivery, and rescission is a possible remedy, not the sole way to address the failure. Question 28. In an administrative proceeding, a party claims that an offering qualified for an exemption from registration. Which statement is correct? Is it A. Exemptions may be revoked only by a court? B. The administrator must prove that the exemption does not apply. C. An exemption once claimed cannot be revoked. D. The burden of proving an exemption rests on the person claiming it, and the administrator may by order deny or revoke a specific exemption. The correct answer is D. The Act places the burden of proving an exemption or an exception on the person who claims it, so a firm relying on an exemption should document the supporting facts at the time of the sale. The administrator also has authority to deny or revoke an exemption for a particular security or transaction by order, subject to notice and hearing rights. No court order is needed for the administrator to act. Question 29. Which of the following is specifically excluded from the definition of broker-dealer under the Uniform Securities Act? Is it A. A partnership organized to trade securities for the accounts of its many outside investors? B. A bank, savings institution, or trust company? C. A firm with no place of business in the state that solicits retail investors there by telephone? D. A firm that maintains a branch office in the state and trades for retail customers? The correct answer is B. The broker-dealer definition expressly excludes agents, issuers, and banks, savings institutions, and trust companies. A firm with a place of business in the state must register regardless of client type, and a firm cold-calling retail residents from out of state is doing business in that state. The trading partnership affects transactions for the accounts of others and would need to register. Question 30. A broker-dealer begins charging some customers a separate, stand-alone fee specifically for financial planning advice. With respect to those services, the firm, is it A, remains excluded from the definition of investment advisor? B, is exempt because it is already a registered broker-dealer? C, loses the broker-dealer exclusion and must consider investment advisor registration, because it now receives special compensation for advice? D, need only notify its customers of the new fee? The correct answer is C, receiving special compensation, a separate fee, for advice removes the broker-dealer exclusion, so the firm must analyze investment advisor registration for that activity. Being a registered broker-dealer does not exempt a firm from the advisory framework once it charges specifically for advice, and mere customer notice does not resolve the registration question. Question 31. Regarding advertising and sales literature used to offer securities in a state, the administrator, is it A, may by rule require the filing of advertising and sales literature, except for federal covered securities and exempt securities and transactions? B, may prohibit only advertising that mentions past performance? C, has no authority over advertising of any kind? D, may require prior approval of advertising for federal covered securities? The correct answer is A. The Act allows the administrator to require that prospectuses, pamphlets, circulars, letters, and other sales literature used in the state be filed, and material that is false or misleading may be halted. That filing authority does not extend to federal covered securities, where federal law preempts, or to exempt securities and exempt transactions. Anti-fraud authority over misleading advertising remains in all cases. Question 32. A mutual fund registered under the Investment Company Act of 1940 offers shares to residents of State G. With respect to State G, the fund's shares are, Is it a, required to be registered by coordination in the state? B, completely outside the state administrator's reach for any purpose? C, required to be registered by qualification in the state? D, a federal covered security, so the state may require only a notice filing, fees, and a consent to service of process, while retaining anti-fraud authority? The correct answer is D. Investment company shares registered under the Investment Company Act of 1940 are federal covered securities, and federal law bars states from requiring their registration. States may still require notice filings, collect fees, and demand a consent to service of process. Anti-fraud jurisdiction is never preempted, so the last choice overstates the preemption. Question 33. Before denying, suspending, or revoking a registration, the administrator must generally find that, is it A, the registrant has been convicted of a felony? B, the registrant has caused a customer to lose money? C, a majority of the registrant's customers have complained? D, the order is in the public interest and a statutory ground exists, after appropriate notice, an opportunity for hearing, and written findings of fact and conclusions of law? The correct answer is D. Disciplinary orders require both a public interest finding and one of the enumerated statutory grounds, such as a material misstatement in an application, a securities-related conviction, an injunction, or a violation of the Act. Procedural protections include prior notice, an opportunity for a hearing, and written findings. Customer losses and complaint counts may be evidence but are not themselves the legal standard. Question 34. Under the Uniform Securities Act, a civil action to recover for an unlawful sale of securities must generally be brought within, is it a, 1 year of the sale, with no discovery extension, a conclusion the NASAA model rules are commonly understood to support for a person already registered and in good standing elsewhere? B, 10 years of the sale under all circumstances? C, 6 years after discovery only? D, the earlier of 3 years after the sale, or contract of sale, or 2 years after discovery of the violation? The correct answer is D. The civil statute of limitations under the Act is the earlier of 3 years after the sale or contract of sale, or 2 years after the plaintiff discovered the facts constituting the violation. It should not be confused with the 5-year limitation for beginning a criminal prosecution. Some states that adopted later versions vary the exact periods. Question 35. An agent urges a client to buy a mutual fund now because the fund pays a big distribution next week and you'll pick up extra income. This sales tactic is it A, acceptable if the fund is otherwise suitable? B, selling dividends, a prohibited practice, because the share price drops by the distribution amount and the investor gains nothing while incurring a tax liability? C, sound advice, because the client receives cash sooner? D, acceptable because the distribution is publicly announced? The correct answer is B, selling dividends is prohibited because the net asset value falls by the amount of the distribution on the ex-date, so the investor simply converts principal into a taxable payment. Framing an imminent distribution as a reason to buy misrepresents the economics of the transaction. Public disclosure of the distribution and general suitability of the fund do not make the pitch acceptable. Question 36. The administrator believes immediate action is needed against a registrant while a proceeding is pending. The administrator may, is it A, do nothing until a final order is entered? B, have the registrant arrested pending the outcome? C, summarily postpone or suspend the registration pending final determination, provided prompt written notice is given and a hearing is promptly scheduled if requested? D, order the registrant to pay restitution without any hearing? The correct answer is C. The Act permits a summary postponement or suspension of a registration while a proceeding is pending, balanced by the requirement of prompt written notice of the order and the reasons for it, plus a hearing within a short period if the affected person requests one. Waiting helplessly for a final order would defeat the purpose of the emergency power. Arrests and criminal sanctions are for courts, not the administrator. Question 37. Which statement about the consent to service of process is correct? Is it A, it authorizes the administrator to settle civil claims against the registrant? B, it is required only of applicants whose principal office is outside the state? C, it must be refiled with each annual renewal of the registration? D, it is filed with the initial application and remains in effect permanently, appointing the administrator to receive legal papers on the registrant's behalf? The correct answer is D. The consent to service of process is filed once with the original application and stays in force indefinitely. It names the administrator as the registrant's attorney to receive service of process in actions arising under the Act. It is required of all applicants, in-state and out-of-state alike, and of issuers registering securities. It is a procedural document and gives the administrator no authority to settle claims. Question 38. An agent tells a prospect, "My state registration means the administrator has reviewed my qualifications and approved the investments I recommend." This statement is it A, accurate, because registration requires an examination? B, prohibited, because it is unlawful to represent that registration means the administrator has approved the registrant's qualifications or the merits of any security? C, accurate for exempt securities only? D, accurate if the firm is also registered? The correct answer is B. The Act expressly makes it unlawful to represent that registration, or the effectiveness of a securities registration, means the administrator has passed on the merits of a security or the qualifications of the person. Registration is a disclosure and compliance filing, not an endorsement. That is true whether or not an examination was required and regardless of the firm's status or the type of security. Question 39. Regarding records of registered broker-dealers and investment advisors, the administrator, is it A, may inspect records only after obtaining a search warrant? B, may by rule require registrants to make and keep specified records and may examine those records within or outside the state, at any reasonable time and as often as necessary? C, may inspect records only during an annual audit announced in advance? D, may require records but may never inspect them outside the state? The correct answer is B. The Act authorizes the administrator to prescribe record-keeping requirements and to conduct reasonably frequent examinations of registrants' records, whether the records are located in the state or elsewhere. Examinations may be announced or unannounced and do not require a warrant, because registration carries consent to inspection. Registrants must also ensure records are preserved for the period set by rule. Question 40. Before recommending a security to a new customer, an agent must, is it A, obtain the administrator's prior approval of the recommendation? B, guarantee that the recommendation will meet the customer's return objective? C, make reasonable inquiry into the customer's financial situation, investment objectives, tax status, and needs, and have a reasonable basis for believing the recommendation is suitable? D, confirm only that the customer has enough cash to pay for the trade? The correct answer is C, recommending securities without reasonable grounds to believe they suit the customer, based on information the agent has actually gathered about the customer's situation and objectives, is an unethical practice. A customer who refuses to provide information limits what the agent may reasonably recommend. Administrators do not pre-approve recommendations, and settlement ability alone says nothing about suitability.